everybody, and welcome back to Eggs, the podcast. But before we get started, I want to talk to you about our sponsor, Taylor Style. It's kind of crazy that we're already in March. The first quarter is almost over, which means that we're in the stretch where everything you said you were going to do at the beginning of the year either starts paying off or it doesn't. And for a lot of you listening, it's conference season, it's board meetings, it's investor updates, it's sales pushes, it's being in rooms that matter. And when you're operating at that level, there are only so many decisions that you can make in a day before your brain is just fried. And for me, that's one reason I love working with Taylor Style. I'm a subscriber right now, and every few weeks I get a box with hand-picked outfits chosen by a real stylist, refined by their AI, and the crazy part is they actually nail it most of the time. Stuff I would never go buy, but I end up wearing nonstop just because it works. Taylor is an AI-powered, human-refined menswear rental subscription. It's built for busy, ambitious guys who want to look sharp, but don't want to spend any time shopping, coordinating outfits, or dealing with laundry. You simply fill out their quick style profile, their AI learns your fit and your preferences, and then a real stylist refines the selections. Complete outfits show up at your door, you wear them, and when you're done, you send them back. There's no laundry, no trips to the mall, no mental energy spent staring at your closet before a meeting. It's one less thing on the list, and in March, believe me, when you're trying to finish the quarter strong, taking even one thing off your plate matters. If you want to simplify your life a little bit and still show up confident in the rooms that count, Eggs Show listeners can get 25% off their first month with code EGGS at taylor.style. That's TAELOR.style. Use promo code EGGS and take 25% off your first month. Taylor handles the clothes so that you can handle everything else. That's TAELOR.style. It's a smart system for people who are serious about execution. And now, back to the show. We asked too, is it just Toerek? Is that how you say the last name?
Sharon Toerek, yeah.
Sharon Toerek.
Correct.
Okay. I should have asked before I got started.
All right.
So, anyway, hey, everybody. Welcome back to the podcast. Today's special guest is Sharon Toerek. She's a marketing and IP attorney for agencies and founder of Toerek Law. Welcome to the show, Sharon. How are you?
I'm well, Ryan. Thanks for having me. I'm excited to be here.
Absolutely. Thrilled to learn a little bit about this stuff. You probably have encountered this in your career, but I think a lot of people don't really think about legal until they need something legal. They don't often think about it as something that you do in advance or, as a precaution to be prepared for, maybe staving off those eventualities. So I wonder if you'd, maybe talk a little bit here at the beginning, just about sort of, who you are, what your career looked like, and, sort of what led you to where you are today.
Right. Yeah. Well, that's a great jumping off point because I do think that legal for entrepreneurial companies should be regarded as a profit-making tool, a profit preservation tool. And I don't think that a lot of entrepreneurs tend to like to think of it that way. It feels more like a cost or maybe an investment if you're being a little bit more generous about it. But it really is, it's intertwined so intimately with your ability to make and keep the money that your business is set up to earn for you. So my background is one of being an intellectual property lawyer originally. It was an area of training that I was lucky to sort of fall into very early in my legal career. And so a lot of brand protection, a lot of copyright and trademark law, some licensing, things like that. And I started to work more with marketers generally because there are a lot of legal issues that arise adjacent to marketing related to IP protection. And then I sort of started getting immersed into the world of marketers, and then more narrowly after that, independent marketing agencies, and they can be agencies of any stripe: media, creative, design, PR and communications, you name it. What they all have in common and who we serve today in my current law firm, which is about 12 and a half years old. It's not my first firm, but we founded this one to serve independent marketing agencies specifically in the United States. And so we help them with IP, contract development and negotiation, and marketing regulation compliance. And before that, I was sort of running this practice and narrowing our client base to this vertical in a silo within a more entrepreneurially focused law firm, which is my last partnership. And I just had a heart for serving these agencies, and so founded this firm that I will own and run to do that.
I love that. Well, and I think what's really interesting is and somebody who's been in marketing basically my whole career, I think there are a lot of misnomers around intellectual property and stuff like that, where people, operate kind of without a net more than they think they are. And on the assumption that, I drew it first, therefore it's copywritten, or I've done this, so therefore I have the trademark, or I'll have first dibs on that,
Mhm.
And I think people have sort of, especially, creative people like myself who draw or illustrate or whatever, we just sort of assume we own our work, because we've
Mhm.
done it. So do you mind talking a little bit about just sort of, I don't know, some common misconceptions or things that might have come up over the course of your career in terms of intellectual property, where people are maybe a little fast and loose with stuff versus, where you should actually be working with an attorney?
Right. Right. Well, I think, fundamentally, most entrepreneurial companies, our client base happens to be entrepreneurial firms that are marketing agencies, but you could be a software developer, a consultancy, or they all tend to undervalue the amount of IP that they are creating on a day-to-day basis. So I think if that's your platform of starting point and you realize that it's your primary product, if you will, and your most significant asset in many cases, especially for small, closely held businesses. So where do we see the most frequent missteps? I think the first place to look for lots of closely held businesses is the fact that they are running with a talent base that is frequently gig based. And the misunderstanding that occurs there, or the misimpression, if you will, is that, well, if I've paid somebody to create some work for my company, that then might get integrated into work that I sell to our clients or customers. I own that. I've paid for that. I've asked them to do it. I've given them parameters. They've created it. I paid them, which is not the way the United States regards copyright law, and which actually isn't the legal basis for ownership of any of the work that that individual or that other firm has done for you. So the first, I think, misstep that lots of businesses make is they're not adequately documenting the ownership trail of the IP that's being created. And it's less of a question when your company pays somebody a W 2 wage to create something within their scope of employment for you. The law is pretty clear about who owns that in that case. It's not so clear when you work with alternative types of talent or subcontractors, or you enter into strategic partnerships with other firms, or you have two company owners who might have each brought some of their own IP to the table to collaborate. So, lack of documentation and lack of a clear chain of title regarding the original creations, whether they're an invention, a piece of technology, an ad campaign, whatever it might be. That I think is the first place to start.
Yeah, no, I think that that's really smart. And especially, I mean, to your point, a lot of people are using gig workers these days and freelancers, contractors, people like this. And so, yeah, I guess not having a clear contract in place or something like that could really leave you high and dry if the assumption is that, just because I paid for it, it's mine. So I
Right.
think that's a really good point. You mentioned in there something about, a lot of these small agencies, especially the closely held ones, are generating maybe more IP than they're thinking of. And I wonder if we could just talk a little bit more about IP or intellectual property as we, I guess, think of it. And the reason I'm asking is because I think for a lot of people, they think of their IP as being their logo, or maybe, some
Mhm.
SOP, or maybe they have some process or an application that they're using. But I think most people aren't even sophisticated enough to have those things in place, right? So if you're just a run of the mill marketing agency and you're just creating work all day long, like, I guess what's the point of protecting the IP if it's just my logo, or if it's just whatever, So like, what am I missing in terms of the kinds of IP that marketing agencies are spinning up that they might not realize should be protected?
Well, I like to you we use at my firm basically a triangle rubric, if you will, for quickly thinking about whether you have IP in your business and what kinds of IP you might have. It's 3 points of the triangle. Top of the triangle, if you will, is brand, and that is how you go to market and how you identify yourself as the source of whatever it is that you sell or provide in the marketplace. And typically, brand is going to be protectable by trademark law. So it's your company name, it's your product names, it's your slogans, your taglines, it's any of the elements of your any of the physical manifestations of your branding. Brand is a very big concept. It goes beyond trademarks, but so that's trademarks and that's brand, and that's really kind of at the top of the triangle. Then you go to the second point of the triangle, and that's your content. And that's probably the broadest. It should be if I had done better in math in high school, I could draw a triangle that had like a really big point. So your content is a broad category, right? It can mean the actual stuff you're creating, your software code, your online learning course, your videos, your marketing campaign materials and collateral. Um, all of that is your content. And that can be protectable under a couple different theories of the law. Typically, it's copyright if you're going to be exposing that content to the world and releasing it publicly. But it might also be a trade secret. It might be something that you have a strategic advantage over your competitors or anyone else in the marketplace with, because it's proprietary to you. It's your secret sauce about how you create, how you deliver, what your standard MO is for doing business. So our legal theories there are either copyright protection or trade secret protection. If it's an original invention, it might be patentable, but I'm not a patent lawyer, so I'm not going to get too deeply into that. But that's the first place that people typically think about protecting IP is, oh, is it patentable? There's so many other theories of protection for your intellectual property, especially in a knowledge-based business. So that's your second very large point of the triangle, because it actually covers the stuff that you are creating and putting out into the world. Then you got the third point of the triangle, which is transactions. And I mean two things by that. Transactions in to your company or your firm. And we talked about one of those types of transactions a moment ago, which is your independent contractor or freelancer or strategic partnership relationships. Anytime you've got some third party who doesn't work for your firm and get an actual paycheck contributing to the content that you've created, that's a transaction in to your business, and that needs to be documented and protected contractually. But then there's your transactions out of the business, and this is the way you actually monetize or make money from your stuff, right? It's the license fees or subscription fees that you charge for your information-based products. It's the purchase price of whatever it is that you're selling your thing for. Whatever your revenue model might be, your transactions protect your revenue model, but they also protect your intellectual property, because your terms and conditions are very important for governing how anybody else out in the world can use what you're giving them access to, particularly in the realm of software or mobile applications or any original creative work. So that's your third point of the triangle, and that's the one that most closely correlates with your money signs. But you have to have the other 2 points of the triangle covered as you go to market to protect those 2 categories of your intellectual property.
Okay. So based on that, I mean, like, it's, I guess, interesting, right? Because I think that those things are the things that even, companies big and small start engaging in, right? They start doing these things. They've got a little name for their shop, or they're creating some content, they're blogging, their newsletters, they're, doing work for clients. And then, obviously, I guess if you're in business, you have transactions going in and out. So because my next question was kind of like, how small is too small? Like, when do we need to begin engaging people, right? I mean, especially for small businesses, I think the notion of spending money on legal is like, well, let's see how long I can kick this down the road. Or, maybe I'm a new business, and so I don't necessarily feel like, what if we don't succeed? What if we're not going to get it? Maybe we'll do okay, but we don't know where we're going to be in a year, so I'm not going to put a bunch of money into legal and that kind of stuff. So from your perspective, and obviously, I mean, I'm sure it's, from day one, but, what's realistically, where do small businesses, at what point makes the most sense for them to start engaging with legal people? Like, is there a dollar amount or some other stage that makes the most sense for them?
I can't speak to a specific dollar amount, but what I can say is that the extent to which your business is founded on a platform of intellectual property and not the actual sale of some physical item can kind of dictate how much energy and how early you want to pay attention to having your intellectual property protection house in order, if you will. And what do I mean by that? I think you need, as an entrepreneur, to ask yourself what would be or could be the damage to the company if someone else was either using a brand or a trademark that was substantially similar to mine. It could cause confusion in the marketplace about who sells what. We see this happen every week in our business. Because trademark due diligence didn't get done, or sometimes inadvertently it happens, and you need to have a plan for what to do. And a lot of your options are determined based upon how well you've protected your IP. So there's a risk calculus that happens for every business owner, right? It's how damaging could it be to our business if we had a trademark infringement problem? Could we weather that storm? Could we afford to rebrand? Could we afford to, or will we have the actual legal foundation to be able to stop somebody from encroaching onto our brand? So that's the first thing. I think the second thing is it's not an all or nothing situation. And every business is different in terms of their triage of which of these they should be tackling and when. But they haven't sat down and actually made the assessment. You should be sitting down and making the assessment, doing the audit of your IP on a regular basis so that you can think calmly and strategically about what your protection plan should be. Perhaps the protection that would be optimal for a particular piece of intellectual property isn't worth to you the risk of a potential encroachment or infringement. You've made that, analysis, and you're okay with waiting. There's nothing wrong with making that, but it should be an intentional business decision. And so I think to answer the question, you have to actually understand the foundation of the IP that's in your business. You need to be doing that analysis. And I just gave you sort of a cheat code for that, right? Look at the 3 points of the triangle, sit down, do some thinking, make a list, and figure out which of those could be most disruptive to your business if you hadn't adequately taken the steps to protect them.
Yeah. No, I think that's right. And I wonder too, I mean, if some of it isn't, I don't know, maybe it's lack of education, right? Maybe people don't realize how much risk they're actually opening themselves up to. I've seen this a lot with especially with small agencies, more on the design side, which is where I lived. More of these companies, I mean, you got a lot of people that are kind of doing creative work that might be a little derivative of something else, or you've got, a lot of agency names that are sort of similar or all kind of look the same, but maybe it's a bunch of people just like you and nobody's going to be, litigious, and you're just going to be able to float. But I think sometimes, you might run into something, or, maybe if you're charging enough for a product, maybe you're doing, let's say like a web design project or something that's really costly. Not having those legal protections could kind of sneak up and bite you, I think. And maybe this is more contractual than it is IP, but it seems like it's one of those areas where especially freelancers or sort of small, single operator kind of businesses might not have protection in place, whether that was, they didn't bother to get a contract or whatever. So is there, I guess, any kind of gotchas or things like that you should be aware of when it comes to that sort of thing? So I'm trying to think of a better example or like a more concrete example here, but I'm just thinking of the idea where, you feel loose and comfortable to just proceed without thinking about the legal ramifications. But the downside of getting caught sleeping could be much bigger maybe than you think it would be.
Right. Well, so I mean, if we run it through the 3 points of the triangle, what are your risks in terms of branding or trademark conflict, right? That calculus looks like what would it mean to our business to have to rebrand, to have to abandon our brand and start from scratch again? What will we lose in our reputation equity? What would it mean like for our client communications? So that's a place to start when it comes to trademark and brand. And when you compare that to the cost of being proactive about, for example, having a trademark search performed, a legitimate full trademark search, not poking around on Chat or Claude or Perplexity or Google to see, do I see any other, conflicting? I mean, obviously start at all the places that are available to you without investment. You can do a lot of this knockout work yourself, by the way. So that's, in the brand family, I'm first and foremost a trademark lawyer. And that's how I got my start as an attorney. I have seen over the years that I've practiced for businesses in all industries what the economic value of a brand is to a company, no matter how small it's starting out, and how expensive it can be to have to abandon ship or beat back down someone else who's trying to steal or conflict with my brand or palm off on my reputation, and our brand reputation. So I think that I guess I would disagree that the question is how much can you afford to get away with not doing. I think the question should be, what are the steps we need to take today? What are the steps we need to take down the road, and then way down the road, to make sure we're making progress, not perfection, right? That's what I always
Sure.
like to say. To move in the right direction, to have a consistent IP protection strategy and a well protected IP portfolio. And remember, you want to be avoiding it's this block and tackle work while you're growing the business, but what we haven't talked about yet is how much it can mean to your business to have a fully protected portfolio of intellectual property when you go to sell it, what it can mean for the value of your company on the market. And so this is why I say, I have a very distinct point of view about this, that legal should be a profit preservation or a money making tool. And IP is one of the areas where that is most true, where that is most resonant, because the more you do along the way to build the legal fortress around your intellectual property as a business, the more it's going to be worth in dollars and cents when you go to get an investor in your company, sell your company, bring a partner into your business, whatever it might be.
Yeah, it's a really great point, and it's actually kind of the next thing I wanted to get into. So it's perfect timing, or a great segue. It's like you're sharing notes here with me. But
We're not,
so
everybody. We're not.
yeah, no, there's no like weird
Ryan and
behind the
I are
curtain
just
thing going on here.
freestyling it. Yeah.
But this is actually one of the things that sort of occurred to me, and so I ran basically a little marketing design agency, but it was basically an extension of my freelance career, we'll say. So like I was
Mhm.
sort of the designer at the center, and I was the center hub. And then, we'd bring on resources or stuff like that to expand and take on bigger jobs or whatever. But at the end of the day, it was still just sort of me. And so in that business, I never put a lot of like stock in the IP at all. I mean, and I did that business for 20 years, but I was like, but it wasn't ever going to be sold. It was just me. It totally hinged on me at the middle. And there wasn't going to be a version of this that I could just package up and sell to somebody. It was just, basically built myself a job.
Right.
And so with our latest iteration of our company, though, I've been much more purposeful on trying to build proprietary tools, trying to build intellectual property that I think we actually could own at some point, and for the purpose of this might be my retirement plan, right?
Yeah.
Like, I'm just getting old enough now that I'm going, well, okay, I spent a life as a freelancer with no 401k, and like I might have to out earn myself out of my irresponsibility. And
Hmm.
so a big part of that is, okay, well, maybe we can develop tools and resources that are actually, worth something. And for purposes that you just described too, like if we were to go and sell, if we've got some protections around the things that we've created, we'd definitely be in a better situation for the sale. But it's interesting just because it never really occurred to me, or like certainly I'm guilty of playing fast and loose with a lot of this kind of stuff, and just working from kind of the artist perspective, which is, oh, well, I drew it, so it's mine, that kind of.
Well, and one of my favorite soapbox. I mean, this is I I talk about this a lot on my show, and actually when I get a chance to speak to audiences of, again, our audience happens to be marketing agency owners, but this is true for any consulting firm owner or any entrepreneur who has a professional service based business, for example, like consulting, education, whatever it might be, marketing agency. The potential for creating a revenue stream that stands up along next to your fee for service revenue. And the example that you just gave painted such a vivid picture of this, Ryan. For the owner of a professional services firm who wants to think about, what could my succession or my exit strategy be one of these days, thinking about your intellectual property strategically is one of the top things you should be doing to figure out how to squeeze the most money out of your business that you can when you're ready to move on to other things. And what do I mean by that? Think about the additional revenue streams that your intellectual property could enable you to establish alongside of your customized fee for service work that you do day to day for the benefit of a client of your firm. If you're a consulting firm or you're a marketing agency, you are charging by the project. Hopefully you're not planning on billing hourly for much longer, because that's going to be a race to the bottom in my opinion, for any professional service firm. But regardless of your business model, you're charging for custom created work for the benefit of your client. But doing that over and over and over the course of months, weeks, years means you're developing your own intellectual property. Great examples of that are you've created a great system for product design or branding or how to do something. Well, turning that into an online learning opportunity, an on-demand course, a keynote presentation that helps you, get the message out to the world about what your company is about. These are all pieces of intellectual property that not only can enhance the value of your company overall, which I mentioned earlier, but maybe you want to close the agency or the consultancy one day, and maybe you want to simply provide for an ongoing stream of revenue because of your information products. Maybe you want to continue to be a creator, but you don't want to do fee for service custom work anymore. Maybe somebody else wants that part of the business and you want to do what, or maybe you want to sell the information part of the business, and cash in on that and close the fee for service side of the company because it's not what you want, or sell that part of it. It creates divisible pieces of the business that not only earn you separate revenue streams that can be as passive as you want them to be, alongside the other things you do to make money in your company, but can be separately sold or retained or broken apart from your main business. And so when you think of this strategically, you are building an asset base that has its own money earning ability. That's the beauty of intellectual property, and that's its proper place in your thinking about how it fits into your overall money making strategy.
Yeah, I love that. And I'll just say that, in my own experience, and maybe this will be the case for people who are listening, but like I have definitely with age started to think more about this stuff. And for me, as somebody who started a business as a designer himself
Mm-hmm.
and was doing the lion's share of the work at the beginning, in the early days, like I grew quickly from 25-year-old guy that could work 18-hour days in front of the computer and just plug away all day into 46-year-old guy that's like, man, I'd really love to just work about 5 hours today and call it good. Like, I mean, I've definitely evolved in my old age. And I think part of that evolution has changed the way that I think into more systems-based thinking, where I
Mm-hmm.
am thinking about building out, different things. And like, I have kind of a setup going where, we do the podcast and then I consult on podcasting. And then we also do, I'm building out the course on podcasting now. And, we've got, I do my weekly newsletter, but my weekly newsletter is based on the transcript from the conversations we have on the podcast. And, like it's kind of this whole ecosystem, right? So everything works together that way. But so to your point about IP, there's IP around each of those little buckets, and I don't know if any one of them will be profitable or make money or whatever, like who knows, but the point is that to your notion of taking something and making it super divisible, I think for people like me who started the business at the middle, you're the plumber who started to plumb, or you're the artist who decided to do art for a living, like where you took your passion and made it your job, basically, instead of building a business. IP might be the way to make your company divisible beyond you as that core freelancer, right?
Mm-hmm.
And so I think for people who are like me, and there's a lot of people who just have started a business because it was the thing they liked to do. They like to do woodwork, so they started a woodworking company, for example. Building these different streams, over time, can certainly make your company into something that is sellable or is more divisible. Like I use the example of my prior business where I was like, well, I knew I was never going to sell it or anything, but in 20 years, I mean, God knows, maybe we did something cool. Maybe there was something we could have sold off, or, if I was being more purposeful about the intellectual property that we were developing over the years, maybe we would have had some things, and maybe, okay, well, I'm going to get extracted and this little piece of the business isn't going to be part, something we could sell, but we could sell A, B, and C.
Right.
So I think just, to your point, I think being more purposeful would have maybe changed my perspective a little bit.
Well, first of all, I don't think 46 is old by any stretch of the imagination. However, yes, it's a key part of thinking about your succession options, as we just went through. But remember that I'm very accustomed to talking with a lot of owners of market M&A, and the marketing agency space is very heated right now. And even amongst the most small of marketing services businesses. So agencies that wouldn't have considered themselves to be an M&A target, a while ago, they're now looking at the what are their options are for making deals. And so, yes, the IP creation, both to enhance the value of your company overall and also to give the exiting owner some options. That's one thing. That's one part of the puzzle. But don't forget about using your business as an ATM while you're still running it, and leveraging your intellectual property to create standalone products, standalone revenue generating offerings while you're running it. It's also a great burnout strategy, burnout avoidance strategy, right? Because you can use the creating and the leveraging of the creations, which you should be protecting legally, as we talked about earlier, to be earning separate revenue streams along the way to give you more options about how you want to move through the life cycle of your company. Yes, it's a great long game, but it's also something that every business owner should be thinking about just as part of their growth and scaling of the business on a day-to-day basis as well. And so I think a short-term, mid-term, and long-term view of this is something every entrepreneur should be doing on a regular basis. And like I said, our lens just happens to be in the marketing agency industry, but you could take those learnings and apply them to lots of other entrepreneurial companies who are earning money in very similar ways day to day.
Yeah. No, I think that's right. Well, let's pivot a little bit and let's talk about AI. Obviously, it's the big elephant in the room right now. And,
Of course, A and I have to go together. Yeah.
Yeah. And there is a ton of discussion out there in the world about, intellectual property or copyright rules as they pertain to AI's knowledge base and everybody having access to the world's knowledge all at once. And, being able to generate a Picasso with a prompt instead of paying Picasso's estate, these kinds of things. And so I wonder if you could talk a little bit about, how AI may have kind of sort of broken the way that agencies used to use, or think about IP ownership, in terms of, I don't know, if the people in their company are using AI for copywriting purposes or whatever nowadays. Like, what does this do to, a company who is trying to create things that should be their own IP, but is this breaking their ownership ability
Right.
by getting into AI tools?
So, I mean, where to start? I think, as we're having this conversation, it's early in the year 2026, and there are still a lot undecided at the highest levels of our federal courts, which is how we decide copyright issues and content ownership issues in the United States, about particularly what the big AI platforms are doing with copyright protected works and what it might mean for our ability to protect our own work moving forward, right? So I would say, first of all, that what we're seeing so far is a willingness by the courts to sort of consider training off of original copyright protected works to probably be allowable and permissible, assuming that the platforms are acquiring their copies of these works legally and lawfully, which has been a huge part of the dispute. So what does that mean? Well, I mean, what does it mean to an average small business who's trying to create and use these tools to make deliverables for their clients and not get everybody sued for infringing somebody else's copyrights? So I think it starts, first of all, with having very well expressed AI policies in writing, both internally at your business and externally with your clients. How do you do that? Well, you know, let's not make this harder than it needs to be. I think it starts as simply as how does our business use these AI tools? Which tools do we use? What are the use cases for our team members being permitted to use them? What do our team members need to do if they want to start using additional tools? And then, I mean, that's a starting point for your own written AI policy in a business. And every business, no matter how small you are, should have one. You should be able to clearly talk to your clients about how you're using AI. And you should be asking your clients and customers questions about how they're using it, what their rules are. Because if you may be a small business, but you may be serving an enterprise size client, or you may be serving a government agency client. And they may have policies around AI use that are very much more conservative than yours are. So you need to know what their guardrails are. You need to know what their expectations are. So have the conversations, and have a guided conversation with them. Prepare your questions. Think about what you need to know from them. So those are your policies, internal and then external, with your clients, with your strategic partners, with your freelancers, because the last thing you want to do is be in the position of telling your client, these are the tools we use and these are the things we use them for, and we don't deviate from that unless we have a conversation with you about it. To then only have your freelancer turn in a project to you where they've gone completely off reservation and used like tools you're not even aware of them having, exposed your client's information to. So that's the first thing, is have your policies in order. Have contract language that addresses use of AI in your professional services agreement. That's the second thing that every business should be doing and thinking about. What are we using? What are we promising you that we will and will not do with AI? How will we handle it if there is an inadvertent infringement of somebody else's copyright or other intellectual property act that accidentally happens because we've used these AI products? This is where, the indemnification and the liability limitation language in a services agreement is important. And for some business owners who are listening to this thinking, we don't include that in any of our agreements. Well, now is the time to start, especially if you're using AI tools to help create deliverables. So it's your policies, it's contract language, and then it's just having a familiar working understanding of what the terms and conditions are of the platforms that you most frequently use. Read them. Have somebody on your team read them, understand them. I can give you sort of a spoiler about IP infringement. The spoiler there is no major AI platform is going to help you or indemnify you if there's an infringement that occurs on your watch because you use their products. That's going to be, your client is going to be on the hook, and you're probably going to be on the hook too, vis-a-vis the rest of the world. So read the terms and conditions of the platforms that you use. So those are 3 simple steps that any business owner listening to this can implement in their business to be more AI ready from a risk management perspective.
So if people are starting to use these different tools, and obviously it seems like right now anyway, there's a new tool every week, but I think the winners are starting to rise to the top. So it's starting to become more clear the companies or the different clients and tools that people are using. But who actually owns the AI assisted work? Is it the agency itself? Is it, because I mean, like you mentioned before, we talked earlier about like using a contractor or a third party human. But if we are using a third party robot instead, so who actually owns that copyright at the end of the day?
So you can only own copyright in human created work. in the United States. So what that means is that if you've used AI to create something, nobody can own it. Now, the question that I always quickly get after I say that is, well, what if we used AI to get started and then we sort of, we use it as inspiration and then we added some human created? There's no metric I can give you. There's no percentage I can give you, because that's the third question I usually get. How much does it have to be human created in order to be ownable? There is no amount. What I can tell you is that as far as the Copyright Office is concerned, and remember, they're not a court, but they are the people who approve copyright applications for registration of copyrights. Their position is that if you can clearly identify the human created content in any work and separate it out from anything that AI generated, you can still own the rights to that work. Why does that matter? Why should anybody listening to this care about that? Your contracts should handle ownership of the IP in a deliverable for an AI assisted work, just like they would handle it for any other kind of work. And that means that anytime you've incorporated some third party content into a deliverable, whether that's stock photography, whether that's a licensed font, or whether that's something that was generated out of a generative AI platform, that's handled separately. And so your agency doesn't own anything that's created out of AI. Your client can't own anything that is generated completely out of AI. It's not ownable, actually. You have to have a conversation about that because your client may not be willing to see the distinction if it's not pointed out to them with enough time for them to think about it and consider it. So the short answer is nobody owns anything that is entirely AI generated under the copyright laws of the United States and just about every other country. If you have an infringement problem because whatever the deliverable is that gets created is substantially similar to somebody else's copyright protected work, everybody involved in the chain of creation or publication of that work is going to have some responsibility. What we don't know yet is how much responsibility, because there's no court decisions yet that are definitive on that point.
Well, Hayden, I just kind of want to point it out. I think that the maybe creates a good opportunity for, small companies. You're talking about, legal protections as a way to be more profitable. It seems like that might actually be a selling point, right? Like, hey, I can use AI and we can get our prices down for you, but you're not going to be able to own any of this stuff. So we're going to stick your logo in it or whatever. But like, if you, as my client, this company B, is trying to grow their IP, it might become very interesting to them if they understood that the tools that they're using to do things more cheaply are actually prohibiting them from developing IP materials that they might want to be building. For a small service provider or something, it might actually be the way to raise your rates, is to say, well, yeah, but we're going to use strictly humans and you'll be able to own all this stuff. But like, ownability might actually become a factor in some of the work you're doing, where I think a lot of times it's just, especially with designers, and I'm just speaking from a design perspective, but a lot of times it's very transactional. It's like, hey, I need a social media ad. Will you just make me an ad? And there's not a lot of thought to it other just we're passing something along. But I don't think people are thinking long-term about ownership of that ad or whatever. We've got their logo in it and their product in it and stuff like that. But I don't think they're thinking about that in terms of a longer form IP strategy, which is we're building these campaigns around products or whatever. And if AI is being used and it does end up negating any like real ownership value of that stuff, maybe social media ads aren't the best example, but there could be some version where you not being able to own that thing is actually detrimental to my client's IP portfolio.
Right.
Where, they may not have realized that before.
Right. Yeah. And I think it comes down to, it's funny, this comes out a lot in a segment of the work that our firm does is in the influencer and creator space. And there's a lot of back and forth that always happens between the influencer or the creator team and the brand team about who's going to own the content, how many rights, how long you're going to be able to use it, and when are the right. And a lot of times these conversations can be very academic, quite frankly. And I say this as an IP lawyer who's a warrior for IP. Sometimes the IP is not that valuable. You mentioned a social media campaign. What will the shelf life of that content be? How long is it going to be valuable, relevant, usable? I think that's an important part of the analysis when it comes to figuring out how much you want to invest in protecting the intellectual property, um, and how you use AI um, in the equation as well. For example, if we're creating a brand, um, and the visual representation of a brand, if we're naming something, we're creating a visual depiction of the brand, like a logo or a set of logos. Those are forever assets, right? They can be. I mean, trademark protection can last forever as long as you use the mark in commerce to sell something. You can own a trademark forever. There's no limits. It's the only kind of IP you can own forever, actually. Copyrights eventually expire, patents eventually expire. Trademarks can live forever if they're, I mean, think of Coca-Cola and how many years that brand has been protectable. That is something you wouldn't want to use AI to help you generate because you couldn't be, sure or confident of your position. But creating a set of social media visuals that um, might last for a season or a reason, that's something you have to be less concerned about, probably. And so you have to do a business analysis alongside of your legal analysis when you decide how much um, investment that you need or want to make in IP protection. And I'm the first to acknowledge that, even though, like I said, I'm a warrior for protecting IP and making sure that you kind of take a pure approach to ownership of it and leveraging of it. Sometimes is the right business decision might be that it's not that risky. Um,
Yeah. Well, yeah, I suppose the reality for a lot of small businesses, especially, is like, am I going to call in my attorney every time I'm going to put something on Instagram? Like, yeah, I mean, of course, it probably doesn't make a lot of sense, but maybe if you're a big enough company, it makes sense to you.
I
But for a
think it
lot of
matter.
people, it's just
Well,
not.
yeah, I think it matters less how small you are than who will see the work, where will the work be published, how, where is this creation, whatever it is, whether it's a video course or whether it's a marketing campaign or whether it's a piece of software, what's the end audience for it? So I think it's less about the size of the creator and more about the size or the impact of the creation. I think those are the metrics you need to be using to think about how much to invest in your IP strategy.
Yeah, I
You
think
might
that's
be a,
smart.
go
I
ahead.
think that's smart. Yeah, I was gonna say I think that's smart, or it's a good delineation. I think because, like, I was just thinking, back to this notion of I'm putting together this little podcasting course, right? But I don't know, maybe on my Instagram I want to share little clips from the course, so I'm sharing my literal IP in
Yep.
Instagram, so even though it's going on Instagram, which I'm being a little flippant of, I am actually putting my real IP that's supposed to have this value out there,
Right.
so not having any protections over that particular campaign might not be the best decision for me. Like if I'm trying to be strategic, right? Maybe I need to be a little more protective of the information I'm putting out there and not so flippant just by virtue of it being social media, rather, making a decision that, yeah, I'm using this channel, but I
Yeah.
am using materials that are, maybe should have a little higher degree of protection or thought around the protectioning.
Yeah. I think that I think one of the hazards of technological advances is that it puts less focus on the independent value of innovation, human innovation. I think this is one of the big battles that AI usage is creating for everybody. What is the true value in business, in commerce, what in culture of actually creating new, originally inspired things and bringing them to life? What's the value of that? And and that I think is a factor in deciding what your IP protection strategy is going to be and what your investment in IP protection is going to be. But over time, the more shortcuts you take, the less value your innovation has. And so I think everybody needs to do their own calculus to determine that, and needs to figure out what their risk acceptance level is.
Yeah.
What their comfort level is with accepting risk of non-protection. And I don't think you should be basing it, like I said, on the size of your company today. I think you should be basing it on the potential value of the innovation and the IP itself.
Yeah. Well, and I think it's a really great point, especially with AI. You mentioned just sort of, with new technology, the world changes and things move more quickly or whatever. And AI has certainly empowered people to punch well above their weight in terms of whatever their established set of skills are or things like that. And, again, just using the design perspective. Yeah, I mean, even, this has been going on for a long time. I mean, even like, the birth of Photoshop took things to another level. And,
Mm-hmm.
and now with introduction of AI technologies into Photoshop or into, Figma and other, design tools, these people who might not have been able to do a thing before now can. Maybe you're not a strong logo designer, but you could go to ChatGPT or something, generate some ideas and get some things going. And maybe one of those ideas is really good, and so you just, apply a color palette to it or whatever and move on.
Mm-hmm.
I don't think people are thinking so long term. I think your point about the trademarkable things like, like your logo, it could really last forever. But if you literally can't own it because the graphic designer that you wanted to pay $20 an hour to do logo work has created a logo out of AI and now it's unownable, I mean, yeah, maybe in the short term, maybe it helped or maybe it worked, but downstream a little bit, it's going to end up being a bigger problem. And so I think that with this technological advancement, there's a lot of these shortcuts that I think are going to start taking place, whether it's people using it to write ad copy or people are starting to, create entire campaigns, video assets, whatever, using these tools. I mean, if at the end of the day you're spinning a lot and creating a lot of work, but not actually owning any of it, I don't know how useful that actually is in the end. And and so to your point, I thought, and I had a little note here, talking about using influencers and things like that. I mean, obviously, this has become a big part of marketing, and so, but it seems then the story about who owns what and when. That's like a contractual deal, right? So, I mean, is that where like sort of contract law starts to play into this stuff? Is just by defining the terms, can we claim back some ownership and things like that?
You can. I mean, whenever it's a relationship, an arm's length relationship between two parties, whether that's two companies or whether it's a creator and a brand or an influencer and a brand, you can contractually resolve all of this, honestly. And you have to, because if you don't put it in place in writing in the form of an agreement between parties, then the copyright law defaults to the copyright law, which means that whoever's created it owns it, right? And that usually doesn't reflect the business intention in an influencer partnership or a creator partnership. So, yes, you absolutely have to have relevant contract language. And that's kind of been a thread that's run through a couple of the things that we've talked about today, right? Freelancer relationships, um, AI tools, anytime there's a third party, whether that party is a human or whether that party is a company or a technology platform, um, pretty much your default assumption needs to be there needs to be some contract language to address the ownership of that end work because um, the way the law defaults is not usually going to be reflective of the party's intentions in that situation.
Well, and I think that circles back to what we've been talking about so much here is the intention part, right? Trying to
Yeah.
make sure that you're actually being intentional with this stuff. And I mean, like specifically with an influencer, I mean, things could go really good or go really bad. I mean,
Mhm.
like if you hire the right person, that's great. If they have some kind of wild scandal that month, then it ends up going really poorly. And if you don't have any kind of protections for yourself, contractual or otherwise, that's you could really find yourself in trouble with something like that.
Yeah, key contracts are a key way of assuring a lot of things, not only about intellectual property and protecting it and the ownership structure of it, but they are critical liability management tools, risk management tools for every business when it comes to knowledge work. And so it is a key part of your toolkit as a business. We have our points of view at my firm about the essential contracts that every marketing agency should have, and it's similar for every industry. There are some non-negotiable agreements that everybody should be defaulting to in their business, just as a risk management strategy and an asset protection strategy for your company.
Well, and so maybe here in the last couple of minutes, it's an okay thing to talk about would be maybe, what is this baseline, for people who have maybe been remiss or playing a little fast and loose with the law, or maybe just didn't even think about it at all.
Mm-hmm.
And now after hearing this conversation, they're going, oh, I didn't even know, so now I'm trying to wrap my head around it. What are the kinds of, I guess, basic documentation? Like if you had to advise somebody who has nothing and they're just trying to get started, maybe they've got a little, some sort of knowledge-based business because that's your expertise. And they, have been in business a few years. They've been just operating, minding their own business. And now they hear this podcast and go, oh crap, Sharon, I need a contract. What am I supposed to be doing? Where would you advise somebody to get started?
Yeah, the best places to start are a comprehensive client services agreement, and in my world that is a master services agreement, but I don't care what you call it, honestly. I just care that you have one, and that is a written agreement between your business and its customers or clients that govern your relationship. That if you're relying on email terms or, just a proposal with a sign off that doesn't have any terms and conditions in it, that's your starting point. You need a client contract that has all the necessary legal terms and conditions in it, to protect the parties. Secondly, you need a written independent contractor agreement with anybody that provides work or deliverables to you that isn't on the payroll of your company. If they're not a W-2 employee, and also please don't call them a contract employee because there's no such thing. If they're a contractor, if they're 1099ing them, you need a written agreement with every single one of those people. Again, not an email exchange, not a call on the phone saying, can you help us out with it? An actual written agreement. And the goal is not to make this more complicated or more difficult than it needs to be. If you have all these as part of your regular toolkit in the business, then there's no friction to getting one signed by every new contractor that comes. Right? It's an evergreen strategy of get your contract toolkit together and then deploy it in all your situations and revisit it once a year so that it's still current and still reflective. So that's the second one. And then I would say, in the knowledge space, probably legal terms and conditions for any of your products that get sort of self-served or released out into the world, your end user terms, if you will. Those are important things to have. Your privacy policy and your website terms and conditions are also very important. We're seeing an increase in data privacy law enactment state by state in the United States. So you want a privacy policy and terms and conditions for how consumers can access your company's website. Those, I think, are good starting points for any business who might be listening to this.
Cool. Well, thank you so much for all this, Sharon. It's been really great talking to you. Any, parting shots? Where can people learn a little more about your business or learn about you individually if they are so inclined?
Well, first of all, Ryan, thank you for having me. A couple places. You can learn more about the work that we do with marketing agencies to help protect them legally at legalandcreative.com. You can come and listen to my show, The Innovative Agency. It's not a legal show. We actually talk about innovation and protecting innovation and innovation from all angles in the marketing world. So check that out. And I'm Sharon at legalandcreative.com. And you can find me on LinkedIn.
That's awesome. Well, thank you so much, Sharon. I really appreciate your time today. Lots of really good information in there. And obviously we could go on a lot longer than this. I've got about another 20 questions, but out of respect for your time, we'll let you go because we'll probably have to start billing me.
We'll have to do a part 2 sometime.
I love it. I'm in. So, well, thanks again so much, Sharon. And thanks so much to everybody who tunes into the show this week and every week. And we'll see you guys next time.